So, hot topic. What's the difference, or should we go to a notary versus a lawyer to do estate planning?
The reality of it is that, and I don't want to say so, but notaries are usually more expensive for the same services.
I've noticed that.
I agree too. They're almost equivalent.
They're at least as expensive, and they're more, and often they're more because they're limited in the services. And so why,
I love that.
And you know, like the big one is the conveyancing. Why the hell would you go to somebody that can't give you legal advice for your $1 million purchase?
Yeah.
You know, it doesn't make any sense. And I know everybody's a little bit, yeah, I can probably tell you this. I shouldn't, but I will. But the reality of it is that, hey, you can use notaries for certain things, but I wouldn't use them for estate planning because is it legal advice when I'm telling somebody? You know, probably. I'm a lawyer, right? And I'm advising them, and you can't get that background. So if you go there and you know everything, and you can get a better deal, save $100 rather than have me draft a will, draft them, and you know everything. Well then, okay, maybe.
And you know everything. That's
right?
the part.
But it's like most people come in there and I explain the background and the law, and I didn't know that, or maybe we should do this, and we have that conversation, which is, to me, the legal advice you can't get over there.
I love what you said about you're actually, it's more expensive because maybe you're not getting the quality for the price. Like that really resonated with me.
Yeah. Okay, so now we're on to wills, power of attorneys, and incapacity planning. Why is incapacity planning, so power of attorneys and healthcare directives, just as important, if maybe not more important, than the will itself?
It depends on the individual coming in to see me, but it's the one time where it's true that if you don't make a decision when you're competent, somebody else will make a decision for you when you're incompetent, and you may not like the outcome. It can be very devastating to a family, with the influence of the government looking at, we're going to look after your best interest now that you're incompetent, and this is what we think is best. And it's clearly not best for the family, and it can be really devastating.
That's the public guardian trustee, right? The
That's
PGT.
correct.
Am I saying it right? Yeah.
That's it. Their mandate is to protect the interests of minors or disabled people, incompetent people, individually. And they've evolved to having policies in place. This is how we do that best. So the example that I dealt with maybe 5 or 6 years ago was, for reasons I didn't know, the main asset of this couple was the house. It had always been registered in his name, and he was losing competence. And what happens if, as I explained to him, it's who you're going to trust, the government to look after you, or your spouse of 40 years or 50 years, whatever it was. Because if you don't deal with things before your competence is gone, the only way to sell the house to get enough money to pay for the care that was coming would be to get a comiteeship order, which means that the public guardian and trustee would be involved. When you sold the house, you get your comiteeship, which gives you your authority to sell the house on behalf of the disabled adult, and they would take half of the sale proceeds and put it in trust, and then they would look after the financial affairs of the disabled adult. So in other words, your spouse wouldn't have a place to live.
Wow.
Right? And there's no argument against it. They don't argue. They tell you what the law is. That's the way it is. And in certain circumstances, it makes sense, but not in the long-term, spousal arrangement. And you can fix that. The last time I had that situation, we fixed it by transferring title to a spouse and gave her the whole house, right? You can do that, no taxes, no nothing, and then when the time was right and the disabled adult went into care, the competent adult sold the property, bought replacement housing, lesser value, and had surplus capital to pay for the cost of care for the rest of his life, which is what you would rather do rather than have a whole bunch of your capital sitting in a public guardian and trustee
Yes.
trust account. And then, of course, when the person dies, then you have to probate the estate and pay more tax on the value of what's left.
Yeah, this is sparking a situation that we had with one of our clients, and I'm just thinking through this. And so, what happens if, let's say, everything's in joint name, and the one spouse does have full-on capacity issues, and they have no power of attorney? Is it that simple that we can still move everything, just remove them from the assets without a power of attorney in place? Or is the PGT still going to have to get involved because there's no power of attorney?
Legally, you can't. If I'm not competent and it's in my name or in my joint name,
Yeah.
you can't have it. There's just no way around it. Now, a lot of the real world works around it and says, yeah, just sign here, but legally, no. You're stuck. And that means you have to get a committeeship order because you don't have a power of attorney.
Right.
So and a committeeship order in terms of cost is 4 to 6 months to get it. That's quick, $10,000, $15,000
Yeah.
in legal costs because, again, you have to get the public guardian and trustee. There's a court application and there's getting the sworn affidavits of 2 medical professionals to explain your lack of competence, and which isn't easy or inexpensive.
Yeah. So I guess to your point, Melissa, at the beginning, is that this is a document that we really do need to address as it's a very important piece of the puzzle.
Yeah, a power of attorney, I used to say that all spouses should have powers of attorney. With the advent of online banking and joint accounts, it's not as necessary day to day as it once was. But it's $300 or $400 to deal with these sorts of circumstances, and to have the security that it's done right, and you're not going to have half of your capital taken away from your spouse because you were in an accident or something. So it is, if it keeps you awake at night, is the way I always tell it to clients. If it's going to bother you, then just do a power of attorney. Now, if you separate and revoke it, there's hundreds of dollars of cost, not tens of thousands if we go the other way.
Does that change like with divorce? You talked about that earlier on with wills and how, laws have kind of changed, or that's what maybe people assume is that if you get divorced or married that it's no longer invalidates the document. If you got divorced and you had a power of attorney with your spouse, your ex-spouse on there, does that document still hold true, or?
The power of attorney continues. It's not, you have to revoke a power of attorney, which is a pretty simple thing to do. It's complicated in the real world because I've registered the power of attorney that you gave me. I've registered it at the bank, so I have access, right?
Right.
And so you have to formally revoke it, and you have to go to the bank and tell them.
Right.
So,
Right.
So it's that's assuming that I'm as evil as you think I am when you were divorcing me, but but that's you have to follow these steps. You have to formally revoke it, but none of it is in terms of legal services. None of it is expensive.
If a spouse, like spouses, one does not have a power of attorney, becomes incapable, the other spouse is capable, can they go get a commonteeship where then they're in charge, not the PGT?
Yes and no.
Okay.
So getting a comiteeship involves the public guardian and trustee.
Oh, okay. Okay.
So you, from the lawyer's standpoint, there's standard form affidavits to prepare and to petition, and there's two medical practitioners that have to provide evidence of the cause of the incapacity, and they have to conclude that the person's incapable of managing themselves or their affairs. The package of material is filed with the court and submitted to the public guardian and trustee, who will offer their opinion to the court.
Okay.
The most judges, while certainly willing to listen to a lawyer and read the materials that put before them, rely a lot on the public guardian and trustee as completely unbiased, and so they're involved. And what happens when a comiteeship order is put in place is they will supervise the spouse or whoever is appointed.
Oh,
You
okay.
can't get rid of them. You have to report to them annually.
Okay.
And so yeah, there's no flexibility there.
Okay. Okay.
Is there common mistakes that people make when they're actually appointing the individual to or individuals to look after maybe their financial power of attorney, their health decisions? What type of mistakes when it comes to selection or of who you appoint have you seen?
I talk to people about, depending on what documents we're talking about, there's different considerations, but certainly from an executor, if I'm appointing one of three children as an executor, so there's no executor fees or anything like that, it's, I ask, where is the appointed executor, where do they live compared to you? Because you can create problems for your family, for your other kids, because, somebody got a point and they're flying out here, every other month they're flying out here from Toronto because they were the right person to appoint. And then eventually everybody's going to say, whoa, wait a minute, because you have to account for all of your expenses. So now we got your flights, we know where you stayed, you rented a car, and you had steak for dinner. And it's like, you want me to pay a third of that? And so I ask people to consider how that looks. Easily from the lawyer's standpoint, you want somebody close at hand to do any of these things. But there's different considerations. The executor, how do they get along with the other kids, the other beneficiaries? Who's the best person, and what does it look like? Are you, because you don't have to share your will with them in your lifetime, are you slapping them and I don't know why they didn't choose me. I'm the right one for the job. I live close. And so that's not a legacy you want. So I ask people to think about that. With powers of attorney, it's more you need somebody close at hand. Again, you need to take that person to the financial planner and to the bank and whatever, sign cards, or they usually need at least ID so that they can take instructions. And having a relationship more than, once every 5 years is probably helpful with the people you're going to be dealing with. On the medical representation agreement, we're looking for, again, somebody that is physically close. The medical representation agreement deals with your care as you age and become infirm, as well as end-of-life decisions. So I always want the person appointing a representative to have discussed with them and come to grips with, in the informal language that I sometimes use with clients, who's pulling the plug,
Yeah.
right? And are they up to it, right? And you know what? When you appoint me to pull the plug, there's maybe there's a new spouse, right? Or somebody that's in a spousal relationship for 6 months that, right? And are we going to be in conflict? How are we deal with it. You know, your choices it's often the same person, but sometimes it's not. And will they do it? You know, some
Right.
people
Right.
have been in my office and discussing these things with their children. And the children, you know, put their hands over their ears and say, I don't want to hear it. You know, parents aren't going to die. And it's like, yeah, they are. And you're maybe having the one to sign the death warrant. And if you're not up to it, and that's the conversation with my client, are they up to it if we put them in charge? So we look for that nurse/doctor that's close at hand, somebody with, and somebody that's been talked to about the responsibility, because nobody signs up for the job, but it's inevitable, and somebody needs to do it.
I like what you said there about discussing things prior to.
Mm-hmm.
I mean, we often say that's one of the greatest gifts you can give to your children or whoever you are asking to take that on for you, especially when it comes to the health decisions, right? And then there's just less family dynamics, because I think we all know that no family is perfect and they all have their challenges. So to be able to map it all out for your kids or whoever's appointing is going to just make everybody's life a lot easier, or flush out, like you said, if they can even handle it.
Well, and these are difficult conversations, and a lot of people don't have them.
Yeah.
The reality of it is that a lot of people, yeah, I'll talk to them, and don't. And,
Cool.
and it's like, you know, I always say the same thing is, you know, get a pot of tea, bottle of wine, get your chosen person over and go through this, you know, because I know spouses that don't have these conversations. You know, and the reality of it is you're being wheeled in for surgery at an advanced age where your chances of recovery at all are 50-50, and your chances of recovery with quality of life are less than that. And somebody says, is there a DNR order on it? And they're going to ask you now for the first time? And it's, you know, that's not the good time
Not
to ask.
ideal.
You know, so, you know, regardless of age, when you're healthy and feeling good and you have your appointed person there, that's when you'd have these discussions, so that if that's what the future holds for you, it's already addressed and we'll deal with it, and I know what to do. But yeah, there's lots and lots of examples of people that don't, and the one that resonates with me that that I'm aware of is somebody was being treated for cancer and was terminal, clearly terminal, and had gone through the whole. It gone through the treatment and given up. Like the medical community had said, no, there's nothing more we can do for you. And at that point, and this was a cancer that had some pain associated with, the medications, whatever they were take this one in the morning, this one at night, and this one as needed, up to 8 a day, right? And the reality of it is people die from a drug overdose when they have that, and it's humane, and that's what happens. So the person in this particular example, in fact, overdosed, and the spouse called the authorities. She's not dead. I can't get her to wake up. And they come, and it's like, well, is there a DNR order? And, well, what's that?
Yeah.
And so what they did is they removed the person, give them that Narcan spray or injection or whatever it is, cleared the system, and put her in hospice for another 2 weeks without regaining consciousness, because they didn't talk. They had no idea what to do.
That is actually one of the first questions that we ask, like when we are with our clients when we're reviewing sort of the estate side of things is, you know, we'll say maybe, who's your executor? They list the executor, then we say, do they know they're the executor? And it's so often that they say, well, no, I haven't told them yet. And I'm like, well, maybe you should ask them if they want to do this. It's always the first. It surprises me just because we're in this industry and we we've had these full conversations with our families because we don't see as much as you do, but we do know there's loads of difficulty. But it always surprises me how many people are like, well, no, I haven't told them yet. I'll tell them when they need to know.
Right,
So like,
right.
no, they need to know now.
Right. And it depends. If you have a spouse, I push really hard. Talk to your spouse because there's, under the Healthcare Consent Act, a spouse will probably be given authority unless you've excluded the spouse and have a representation agreement appointing somebody else. But have you talked to your spouse about what happens with me? What happens if? When there's no spouse anymore, then it becomes even more difficult because you're
Yes.
choosing, and I find, in my experience, most times the spouses have either had the conversations or told me they've had the conversations. I know that there's some people that just can't talk about such things, but I think there's, for the most part, between spouses. But now when you go to a generation and talk to your child or a friend or something else, that's when there's a real lack of communication. And a hard push for me because the agreement will probably be enough, but only probably.
So what happens then? Like you mentioned that usually, even if you don't have like the representation agreement, they'll appoint your spouse. But what about if we're down to the last, the last parent or family member, and they have not discussed this, they don't have capacity anymore? Will they look to the children?
They will. And a lot of the Representation Agreement Act is to protect the medical community. We want somebody to sign off on. We have something called the Healthcare Consent Act in BC, which lists who can make end-of-life decisions for you. And we want the representation agreement because that appoints and
Protection for them, it sounds like.
For the
for
medical
them,
community.
Yeah.
right? This is a big part of the Representation Agreement Act. So, and under the Healthcare Consent Act, if I'm your neighbor and you've fallen and I throw you in the van and get you to the hospital and there's nobody else, I can sign, right? It is protection. We look
Okay.
for, in a perfect world, we have this listing. Is there a spouse? But we need to make a decision, but the spouse isn't here. So, you can run into problems. Whether that bothers you enough to need a representation agreement is, an individual choice, right?
So you don't see more of an urgency with kind of our healthcare situation in general, like in Canada. Like, we're kind of at all-time extremes where wait times are long. We're seeing a lot of actually like really crazy things in hospitals now where people aren't actually getting in that need certain treatment and things like that, and end up actually in some really horrific cases like actually passing away without even making it into be assessed. Will the representation agreement, do you see, be more necessary as things, if our healthcare system doesn't get fixed?
I think it's becoming more necessary, certainly in our community because we have the older population.
Right.
And most of the assisted living businesses insist on having a representation agreement because they want to know who they're dealing with. They can't deal with
Okay.
with the patient, so they want to know. And there's pressure applied, and I've had many people come to see me and say, "I'm told I have to have one." And the reality of it is you don't. It's not a bad idea as long as your representative understands that the obligation just isn't to make decisions. It's also to advocate. In the real world, oftentimes, if there's a DNR order in place, for example, or an equivalent representation agreement that's not being advocated with, you have your care at the hospital and we're going to put you over on this side. But if we have somebody there that's advocating for you, we're going to put you over on this side. It's a little bit different
Right.
quality of care. And, there's no blameworthy conduct going on. But that's the reality of it is that the quality of care you may get if there's a representative who's not advocating for you is probably less.
Yeah,
Right.
And
makes
and
sense.
so, to me, I want the representative to know that and to be and understand what the task is. It isn't simply making a medical decision when a doctor calls and say yes or no or pull the plug or not. It's the representation agreement survives. It's enforced when it's executed, and somebody may be there for 5 or 10 years. And what do?
Right.
Can you not move away from grandma that's in care in Parksville?
That's a huge ask.
It is. It really is. And usually there's no problem with it, but it's a lack of understanding of what's involved. But under the Representation Agreement Act, the medical side, because there's a financial one as well, but under the medical one, if you appoint me, I can decide where you live. I can decide who visits you. I can decide your activities. I can decide your church.
It's pretty
All of that.
intimate.
It is. I've taken complete control over you, and I've seen it abused, not frequently, but I have.
Right.
You appoint your ex, right? And then you never renounce it, and you become incapable. And it's like, they're just waiting for you to die so they can collect the inheritance or something. That's kind of extreme, but I've seen it happen where I'm not really interested in spending more money on the quality of care,
Right.
and I control it.
Right.
And so, your personal comfort doesn't matter.
I enjoyed this part of the conversation about the advocacy part of a representation agreement so much, because everybody just talks about the responsibilities of the care, but not necessarily, making sure it's the care that you wanted or being looked after as best you can.
I know the answer to this already, but I figured it would be good for our listeners to know as well. Can we appoint a lawyer to act for our medical decision making, or a trust company or something like that if that burden is too much on our family?
You can appoint anybody, but it's certainly not recommended.
Right.
It's working for those that need it. Working in consultation with somebody, a professional third party, is maybe the best you can do. But the idea of an end of life decision, in a representation agreement for a company to make, right? Like, you're not going to get there's no exercise of discretion and things like this. And so you really need somebody. I tell people the same thing. We need somebody that you trust implicitly, that has a loving relationship with you,
Right.
that will do
Yes.
the best thing for you in accordance with your wishes, whatever they may be. And I don't have to agree with your wishes, but I have to, and the representation agreement comes in many different forms. The ones that I was preparing, very detailed, that say what my wishes are and spell it out. If this, then this.
Right,
And even of that, it's somewhat vague, because saying I don't want to return to this sort of treatment if I'm afflicted again, because I know it's not going to bring back quality of life or anything. You can't really say that, because you don't know in the future with advances that it might be
Right.
part of a full recovery. So
Right.
now you've made it impossible. So it's having that relationship with somebody is important.
This has been such an enjoyable episode so far, and we're learning so much about estate planning from Bruce Soloway that we have broken this into 3 episodes. So please come back for part 3 of our estate planning series with Bruce Soloway.
Thanks so much for watching and listening to today's episode.
As always, you can check out our website, islewealth.ca, or follow us on Spotify, YouTube, or Instagram.
Thanks so much.
Bye for now.
Corporate disclaimer. This podcast has been prepared by and with expressed opinions of Joanne Cabin and Melissa McGuire, and are not necessarily the opinions of Raymond James Ltd., RJL. Statistics, data, and other information presented are from sources RJL believes to be reliable, but their accuracy cannot be guaranteed. This podcast is for informational purposes only and should not be construed as an offer or solicitation for the sale or purchase of securities. Investors considering any investment should consult their investment advisor to ensure that it is suitable for the investor's circumstances and risk tolerance before making an investment decision. Past performance is no guarantee of future results. Information provided in this podcast is general in nature and should not be construed as providing legal, accounting, and/or tax advice. Should viewers have any specific questions and/or issues in these areas, please consult a legal, tax, and/or accounting advisor. RJL is a member of the Canadian Investor Protection Fund. Raymond James USA Ltd. advisors may only conduct business with residents of the states and/or jurisdictions in which they are properly registered. Raymond James USA Limited is a member of FINRA and SIPC. We hope you enjoyed the podcast, and for more information, please visit islewealth.ca.